Good
And
afternoon,
then,
Your Honor. I'm
and it,
Timothy Hom.
okay.
No harm taken over the mispronunciation. It has happened since childhood. So,
I can
um,
imagine. And you said it's Hom.
yeah, I did make a joke. It's kind of late in the afternoon, but I used to make a joke about being a delicious piece of meat when they mispronounce it.
There you go. So let's start with this, folks. There's a lot going on here. I'm going to say that. There's a lot of.
Today, we are going to break down a courtroom battle that quickly proves this case is far more complicated than it first appears. The judge opens by acknowledging the mountain of filings before the court, while the self-represented defendant immediately argues that the entire lawsuit should fail because the agreement at the center of the dispute was never properly executed. Before either side can dig deeper, the judge shifts focus to a crucial procedural question that hints this hearing is about much more than just paperwork.
Filings, there's dismissals, there's stay in discovery, there's federal due process implications requested.
Your Honor, I can make it brief because they did respond to it and said that there was a slew of filings. One of those filings was to preemptively stop them from dismissing it without prejudice so they could pursue to harass me further with litigation because that was my perceived posture that they were taking. So all that I'm asking for this is, and they stated it requires conversion to CR 56 if outside evidence is relied upon, because I said failure to state a claim. I said failure to state a claim because without an effective agreement.
The plaintiff finally takes the floor and changes the tone of the hearing. While claiming the dispute is merely procedural, the attorney delivers a serious accusation, arguing the defendant submitted an inaccurate declaration about treating Washington patients. That single claim suddenly raises questions about credibility, jurisdiction, and whether additional evidence must be gathered before the court can even consider dismissing the case. What seemed like a technical dispute quickly becomes a battle over fact.
They have no claim for harm that occurred, and they brought this under an agreement that was never fully executed on their part.
Okay.
So it's sorry.
So you're asking for a summary judgment hearing?
I am not asking for a summary judgment. I'm asking it be reviewed based on the written record alone because they provided the court with the copy of the agreement that was never signed on their part, and it did not comply with Washington's statutory requirements of non-competition agreements.
Okay. Anything else before I go to the other party?
If that is not done, then if this does require CR 56, conversion, then to continue to schedule that, but not allow this to proceed based on, before merits hearings or discovery are allowed, like the threshold issues that are at issue here should probably be addressed, and they don't require a hearing. And I can specifically state why each of those, if you would like, right now.
Not yet, but hold on. Are you planning to hire an attorney, or have you hired an attorney?
No, I am not planning to hire an attorney. They inappropriately served a tenant at my property.
Okay, so I don't want to get into the matter. I'm just asking. So you are.
Today, the defendant fights back with a detailed explanation, insisting every patient interaction occurred outside Washington, and arguing the plaintiff is exploiting Washington law because Oregon's legal requirements would have been much harder to satisfy. He challenges the evidence point by point, but as the arguments grow increasingly detailed, the judge recognizes the discussion has crossed into the actual merits of the lawsuit and immediately steps in to redirect the entire hearing toward the proper legal process.
That's a threshold issue, though.
No, sir,
proper service.
No, sir, you're going to answer my one question right now in front of you.
I am not planning on obtaining an attorney. If I do, I will notify you.
Okay. All right, let me go to plaintiff. Your position on today's motions.
Thank you, Your Honor. As we see it, the motion is for some specific relief, and it's purely procedural. That is for the court to set a hearing date and briefing schedule. And we don't have any opposition to that. Defendant is certainly entitled to bring the motions that he sees fit. The only thing that we ask is that he do it in compliance with the same rules that we have to abide by. And in the relief he's requested, as the court noted, it's pretty broad at this point, but it includes at least motions with regard to service, motions with regard to whether there is jurisdiction, motions with regard to whether there's a claim stated, motions with regard to what forum law should apply, and kind of an omnibus, the case should be dismissed because defendant disagrees with it. We would note that particularly with regard to the jurisdictional issues, which sometimes can be done based on an affidavit, that here they fall within the ambit of CR 56 and need some CR 56F relief. In particular, one of the things that defendant put in his supplemental declaration now before the court is that he is currently serving no patients in Washington, which presumably would go to.
The courtroom becomes noticeably more tense as the judge explains how the case will proceed through a formal summary judgment process. Rather than accepting the ruling, the defendant repeatedly attempts to revisit jurisdiction and challenge the court's reasoning. Each interruption is firmly shut down until the judge warns that continued interruptions will result in being muted. It becomes a clear demonstration that courtroom procedure ultimately outweighs personal disagreement, no matter how strongly either side feels.
Jurisdictional defense. He has since admitted in an email to me that he is at least have one Washington patient in Eastern Washington. And I'm sure he has reasons for why it shouldn't apply to this case. But the point is the declaration that he submitted to this court on issue of jurisdiction is not accurate. And there may be other inaccuracies that we need to look into so that the record is complete. So I think the best, most efficient way for the court to proceed is to set a hearing on a motion for summary judgment calendar. Defendant can decide what he wants in that motion. We reserve the right to object if it's improper under the rules. And we proceed in that direction with the notion that we will have to do some initial discovery with regard to the declarations that defendant wants to rely on.
Thank you. Go ahead.
Can I respond?
Yep, this is your time to respond.
Okay, so I actually provided in good faith a list of the appointments that I have had since separation. I was terminated. I did not resign as they, provided as evidence to the court. I did not resign. All of those were in the state of Oregon, with the exception of two, which were virtual visits in the state of Nevada. I provided those as good faith evidence that they have no harm in the state of Washington. Any harm exists in the state of Oregon, and they are attempting to get around Oregon's law, because in Oregon, if they were to have tried to enforce the agreement, they would have had to notify me within 30 days, and they would have had to pay me 6 months of wages for them to even have the ability to do it. And then I could have the ability to prevent it from occurring. They did not do that. Instead, they provided speculation about things, and in the attorney's own response, he admits that he relied upon a website address that said, "Come see us in person." The plaintiff, as it related to them, I provided mobile wound care for them. They should be very well aware that the address of the company, there's in Oregon, for example, is a PO box. So it's really not expected that anybody sees patients at a PO box in Salem, Oregon. And it was also an oversight from a generic template builder. And to refute that address being used, they relied on a different address in the state of
Okay.
Oregon.
So- Right. So we're getting into the merits, and here's what I'm going to do. There, it is very clear.
So
Oh, hold on, sir.
is it,
Hold on. I'm telling you what we're going to do next. Shake your head if you want, sir, but I'm about to tell you what we're going to do next.
I'm not shaking my head. Okay.
Okay. It is very clear to me that along with
As the hearing draws to a close, the attorneys focus on scheduling while the defendant makes one last effort to convince the judge the lawsuit lacks any real legal foundation. He argues the plaintiff came before the court with unclean hands and never demonstrated actual harm, but the judge remains unwavering. Explaining those issues belong at the future summary judgment hearing rather than today. The hearing ends with the next court date set, and the central legal battle still waiting to unfold. If you enjoyed this courtroom breakdown, make sure to like the video, subscribe to the channel, and turn on notifications so you don't miss future cases. Thanks for watching, and we'll see you in the next video.